Hey everybody, John Michael Bailey Injury Lawyers, and we are pleased and proud to be joined today by our Chief Legal Officer and a recognized expert and authority in workers' comp, Mr. Mark Lambert. And today we're going to talk about how a lot of us from the South count, and that's on our fingers and our toes. And so I'm gonna turn this over to Mr. Lambert, let him kind of give us a little outline, and then I'm going to ask a few questions along the way.
A lot of the calls that we get are from people that work in construction. A lot of the calls we get are from people that work in factories. And a lot of the calls we get are from people that work in transportation and packaging. All those jobs have one thing in common. You use your hands all the time. The second thing they have in common is you're on your feet all the time. So fingers and toes become really important parts of being able to do those jobs. The other thing they have in common is that they're dangerous. We have people that call us not because they want to tell us how great their hands are doing, but because they've suffered an injury to a hand or to a foot. Insurance adjusters, they want you to think that an injury to a toe is just an injury to a toe, or an injury to the tip of your finger is just an injury to the tip of your finger. They'll make sure they send you to a doctor that specializes in only that body part and doesn't look at any other body parts. They'll make sure that they tell you that hand injuries and foot injuries they're treated differently under the workers' compensation system. The math's not the same. The math is less. They're just not as important. And they'll even tell you that some of your fingers are much more important than other fingers, and some of your toes are much more important than other toes. The problem with all of those not facts, because none of that's true. The problem with treating your claim like that is that it doesn't put you in a position where you can get back to doing the same job that you were doing, or sometimes any job. Let me give you an example. If you have an injury to a toe, let's say you're wearing a steel toe boot, something falls on that foot.
You're at a construction site, somebody doesn't secure a beam or something, and it comes down, and even though it hits your steel, we've seen this before, even though you're wearing the steel-toed boots and you've done everything to protect yourself, it still hits just the right way, and it comes down and it can either crush or amputate the big toe.
Sure. Or gets clipped by a car tire, a delivery vehicle. Any of those things can
Run
happen.
over by a forklift. We've seen a bunch of those.
Sure. Well, that toe may be just a toe, but what a lot of people don't realize, and certainly what an insurance adjuster is not going to help you realize, is that missing any of your toes is going to cause you problems with perhaps a leg, perhaps your back, perhaps a hip. Those injuries can go all the way up your body.
Well, let's explain that. Let's talk about that, and let's just use the big toe as an example of how that can actually go up through the entirety of the body.
Sure. If you lose your toe, let's say your big toe, obviously you've got a toe problem and you've got a foot problem. Those are easy. But imagine now, you've got that toe on your left foot that you're missing, or that toe on your left foot that's injured. Even if it's just in a cast or a splint, you're going to start to do what? You're going to favor?
That's right. You're going to compensate, and your body is going to compensate.
The other foot, and the other leg, and the other knee. And that's where we see a lot of problems develop. An injury to your right, or say your left big toe, can cause a secondary injury to your right knee.
And that insurance adjuster is never, ever, ever going to ask you about that or tell you about that possible connection. In fact, that adjuster is going to tell you the two are not related.
Worse than that insurance adjuster is probably going to be backed up by the orthopedic doctor that you got sent to for your toe. Not because he or she's a bad doctor, because their specialty is the toe. Their specialty is the foot.
And that's all they're going to look at.
They're going to tell you, I was authorized. I was told to work on your toe and your foot. That's what you were sent to me for. If you're having knee problems, you need to tell somebody. Talk to your insurance adjuster. Maybe go to your family doctor and tell them, but that's not what I'm here to treat. I'm only here to treat your toe and your foot. So many people feel completely left out of the system because they know in their heart that that knee pain is related to the foot injury, but nobody will listen to them.
We will.
We will. It can get worse than that, though.
But when we try to rebalance ourselves, and I guess we're sticking with the left foot, that can actually cause us to adjust the way that our hip works.
Mm-hmm. We call it gait derangement.
Okay.
Gait derangement is whenever you change the way that your feet move in relationship to each other. Instead of you having a full gait, meaning a full step, one of them is shortened or one of them is lengthened to try to get the same type of locomotion and mobility that you had before, but without the full use of one of your feet and one of your legs. When that happens, guess what compensates for it? Your hip and your back. So again, people come to the doctor and they say, "Doctor, I know that I have a foot problem here. You've agreed I've got a foot problem and a toe problem, but now my back hurts and my hip hurts. And I get this popping and this creaking and it sounds like gravel in my hip and in my back." And the doctor says the same thing. "I'm authorized to treat your foot. I'm authorized to treat your toe. If you have a back problem or a hip problem, you're going to have to call somebody else." And that's not the doctor being rude. That's the doctor being honest. They're only getting paid to treat one body part.
That's what they're authorized to treat. That's the only thing that they're going to treat. All right, so let's say that I've lost my toe. I've noticed that my knee is starting to lock up, that my hip aches when I go home at night, and I have to put a heating pad on my hip, and my back is sore, and I'm just, it's affecting my mood. I'm grumpy at work. I'm grumpy with my wife and snappy to my kids. And I pick up the phone and I call and I speak with Mr. Lambert. "So, Mr. Lambert, what are you going to tell me that I need to do when I tell you this entire scenario? I lost my toe. The doctor says, yeah, you got a toe problem. Yeah, you got a foot problem. But, I'm not hearing anything about the knee and the back and all that other stuff, because that is beyond the scope of my treatment of you. And when I call the adjuster, the only thing I get is crickets. What can I do, Mr. Lambert? How can you help me?"
Well, there's a couple of things that we can do. First, it's a sad reality that a phone call from a law firm makes a bigger difference to an adjuster than a phone call from the employee. It shouldn't be that way, but that's just the way that it is. So when I call or our workers' compensation coordinator calls, we get a different set of ears than when the employee calls. We'll remind them that these things are possible. We'll even send them studies, and more importantly than that, cases out of Tennessee and Mississippi where the courts have found that these secondary injuries can be related back to the primary foot and toe injury. We'll send those to the adjuster and try to make them see the light, because frankly, that's the easiest way. If that doesn't work, the next step is to go back to the doctor that had a closed set of ears. Again, when it's me or the workers' comp coordinator from our office calling the doctor's office, sometimes we get a different opinion from them than you got as the employee. I have a clearly worded letter for just about every occasion that I can send to a doctor that doesn't require them to do anything except check yes or no on that letter and send back to me. What that does is that gives the doctor the freedom to express their opinion that yes, the knee is related, yes, the hip is related, yes, the back is related, without taking an hour to dictate a medical report, without trying to get the adjuster on the phone. All they've got to do is check a little box, and then it's my job. Then I take that hour and I get the adjuster on the phone, and I've locked them into a good medical opinion from the doctor that they chose. That works more times than not. Now, on the occasion that neither of those things work, we can always hire our own doctor who'll give a more holistic view of the entire body, do a greater review from head to toe of all the things that could have been caused by this injury. The important thing to remember is that you're not the one that caused this injury. The employee's not the person that wanted the hurt knee or wanted the hurt hip, but often you get blamed for complaining about things that the adjuster can easily say, the doctor too doesn't agree were caused by this injury. That's not your fault. Even if you've had pre-existing conditions, even if that wasn't a perfect knee, you hurt that knee playing football in high school or at your last job or up on a ladder or from doing yard work, it doesn't matter how that knee was doing before you got injured. If you were able to do the job and do the work, then that knee was good enough. And even if this exacerbated or aggravated some condition, the employer should be held responsible for it. And sometimes you're only going to get that if you become the squeaky wheel. And sometimes you need an attorney to do that for you.
What I'm hearing is that even if you had a prior injury to your knee, or we're about to go into the elbow because we're going to talk about the hand here in a second, that's, if you hear the word asymptomatic, that means it might have been injured, but there were no symptoms, no problems. And now, since the injury, the problems have started up. That's called exacerbation. And so if you see in your medical records asymptomatic or symptomatic or exacerbation, that's what that means. Is that right?
That's exactly right. And
Okay.
once we tell that to the doctor and we say that my client had been working for this company doing the same job for 6 months, 2 years, 5 years, and had never complained of knee problems, and now 3 months after this injury to their foot that caused them to be in a cast or on a crutch or to have lost their toe, they suddenly have knee problems. Doctor, isn't it possible that this is causally related? And isn't that possibility to a greater degree of medical certainty than not? And if the doctor agrees with that by checking yes on it, then whether the workers' comp carrier likes it or not, you've not got just a foot injury. You've got an injury to the knee and possibly to your whole body because of your back and your hip being related too.
All right. Well, let's say that instead of that steel beam falling on a foot, let's say that there's something wrong with the machine that I'm using, and I'm feeding things into the machine for processing and packaging. The machine glitches and it takes off the first half of my index finger. Tell us what would happen in that scenario.
Gosh, we're talking about the big ones here, the big toe and the index finger. Obviously, those are the two phalanges that we think about the most with these injuries, and they're the ones that get hurt the most. But when we're talking about an injury to the index finger, I mean, a lot of things come into play. Obviously, is that your dominant hand or not? Is that the hand that you've always used to write with and do things around the house? The second thing is, what kind of vocation were you involved in? I make the analogy sometimes, and it comes off as a joke, although it's not meant to be, because anytime you get injured, there's nothing funny about that. But I make the analogy that there are many injuries that I could suffer as an attorney that wouldn't cost me anything in my vocation. If I'm walking to the courthouse and a car jumps the curb and I have a terrible injury to my leg, I can still go to court. I can still go and argue. I can still do all the things that I could do before. But if I drive a forklift, that's a completely different analysis. The same thing holds even more so true when you're talking about your hands. When you're working with your hands day in and day out, and you've gotten used to doing a particular job, and that's the only way that you know how to do it, then it's so much less likely you're going to make a meaningful return to work if you've lost a finger. Obviously, there are more injuries. We're going to talk about those here in a second that, just like with your foot, you can lead to other body parts being injured. But the amount of use that we have for our hands in our daily function, daily life, and even at your vocation just can't be overstated. So the question really then doesn't become about that finger and not even about the rest of your body, like we talked about with your foot. The question then is about your job. Can you go back and can you do that job? Can you go back and make a meaningful return to work and make the same living that you did before you lost that finger? Those are things that are fact intensive. We have to ask a bunch of questions. They're questions that we're going to set you down and we're going to go through all the things that you do in your daily work. We're going to make sure and educate the doctor as to those things. The doctor may only know what position you were at your job, if they know that. Often all they know is what the injury is. We're going to make sure that they know what position you were in and how that position caused you to need to use all 10 fingers all day long to be able to make a meaningful return to work.
Okay, so for a concert pianist, if they lose their index finger, that's a big deal. What about somebody shucking oysters?
Well, that's a good analogy because there's a quite famous case about somebody who was at just that position, an oyster shucker. And the Supreme Court decided that they would go deep into the facts of the case. And what they found is because this person was an oyster shucker, they never learned to read, they never learned to write, they didn't do math. The only way they could sign their name was with an X. And just as importantly, their dad was an oyster shucker, their grandfather was an oyster shucker. They found that that was the only job that this employee was qualified to do. There weren't any other jobs that they were qualified to do. And because of that, the court found that they were permanently and totally disabled. There's a good graphic that we can sort of make with our hands when we talk about this. Once you get injured, before you got injured, there were all these jobs you could do. We have to show the court through the doctor and through all these other processes, that injury, no matter what it was, shrunk that amount of jobs you could do down to what the reality is. There are so many jobs out there that you're barely qualified for, and once this finger's gone, you're not qualified for. We have to communicate that, and just like in the case of the oyster shucker, that guy's job possibilities went down to none. We've got to ask all the right questions to get all the facts to see what your job prospects are after this injury.
And what we want you to take away from this is that if you do not stand up for yourself or have somebody stand up for you and fight the workers' comp adjuster and the entire workers' comp system, you're going to get what they're willing to give you, and they are never willing to be fair. You've got to remember that if workers' comp adjusters and the workers' comp system did the right thing every day, there would be no need for us, and yet we're very busy every day. So if you've been injured, I don't care what body part it is, pick up the phone, 888-WE-FIGHT. Mr. Lambert is here waiting. I hate to say this, he gets to the office before me, and a lot of times he's there after I leave. And he deeply cares about each and every person that calls on him for help. So again, 888-WE-FIGHT, www.calljnb.com. We're open 24/7, 365. We never close. If you're hurting, we're working. Thanks much for listening, and we hope to see everybody really soon. 888-WE-FIGHT.